Well, they're there and somebody's talking, but I'm not hearing anything.
Martin, is that you?
Yes, it is.
This is Dennis.
Hello, Dennis. Good afternoon.
Good afternoon. I'm in the same position. I can see someone talking, but I can't hear what they say either.
Well, thank you for letting me know. I thought maybe I was being computer illiterate.
No, no. Oh, well, we're both in the same position.
Okay. Can you, so Dennis, can you, sorry, can you hear me now?
Yes, we can.
Yes, yes, we can.
Yes, thank you.
Thank you very much.
Okay.
Thank you.
All right, so we just, so Dennis, right, so we're just getting up. All right, so we're just getting underway. I don't know if the Honorable Madam Justice Chantal Nanai, who's there, I think she promised to be with us as well, Judge of the Caribbean Court of Justice. Underway. Can we mute those online so that Honorable Justice? Can we just mute everyone? So for as well, Judge. Sorry, His Excellencies Ambassador Sejun Kwon, Ambassador of the Republic of South Korea, Professor Derek Cheney, Vice Principal, University of the West Indies, Dr. Rampersad, of course, my co-author, and of course other members of the
Regretfully, we have lost the sound again.
Yes, we have. Yes, I don't have any sound either, Dennis. Pardon? Well, I don't even I can't even see anymore.
Neither me. This screen has gone blank.
mentor, this is supervisor, and the mentor provides all
You know, the food, you know, you know, it's seen everything. Because one of the things he likes to think of himself is that he's very youthful. So you don't use the word senior with him.
This screen has a main screen.
So anyway, I know what it is like to supervise students, and I know what I had to think of himself. So there was no or unique here in Barbados, Dr. Hamid Ghani, political scientist and former director of the U.S. Institute of Social and Economic Research, UEC Augusta, Professor Stephen Bastian, president of the University of Technology, Jamaica, or unique here, former the treaty was signed on behalf of Trinidad. And also Navit to have the headquarters of the CCJ located in Trinidad and Tobago. Former Prime Minister of St. Lucia, Dr. Kenny Anthony, who's now parliamentarian in the St. Lucian government, and also the husband of their principal, was also interviewed in his capacity as legal counsel to carry out having undertook the necessary groundwork and was involved in drafting the treaty established in the CCJ. We also interviewed Sir James Mitchell, former Prime Minister of St. Vincent and the Grenadines, who does not support the linking from the Privy Council. Crispin Moore, Attorney Law and former Minister of Justice and DNT, and Marlene Malcolm Ford, Attorney General of Jamaica, were interviewed to elicit the opinion of members of the legal fraternity in the region. Secondary research involves analysis of relevant materials in books and journal articles with focus generally on subjects such as regional integration, regionalization, and regionalism, globalization, and international and regional courts, and more specifically their relevance to the Caribbean. Yes, the CSME and the CCD and its jurisprudence. It also includes an examination of newspaper articles, both print and electronic, with a focus on commentary and public opinion on the CCJ and its decision. The CCJ has indeed been a pillar of strength and support for the regional integration movement, successfully propelling the regional integration agenda. This is so despite its many challenges, particularly the reluctance of the majority of CSME states to subscribe to its appellate jurisdiction. Though only 5 states have subscribed to the CCJ's appellate jurisdiction, together they have brought a total of 386 appellate matters to the CCJ. That's the last figure I got, but I'm sure there are more since I got this data, because they come in fast and furious. As compared, this is interesting, the 35 in the original jurisdiction, of which all 13 CSM states are met. So 13 states has brought 35 cases in the original jurisdiction, and 5 countries, you'd say 4, St. Lucia, I don't know if they brought any case there, 2 from St. Lucia, but 5 countries, 386 cases. That in itself, I think, suggests to us the significance of subscribing to the appellate jurisdiction of the CCJ. Now that is the big controversy. I could just pick up it and talk about the last bit, particularly chapter 5, which address a lot of constitutional matters, and the judges dexterously, insisted upon a liberal purposive approach to constitutional interpretation. So chapter 5 looked at the constitutional cases, some of which also human rights cases like Joseph and Boyce. And there were many land cases which addressed that phenomenon of delay, particularly in the local judiciary, the Court of Appeal, the High Court, the Magistrates Court, wherever they may have come from, to the CCJ. It is an endemic problem that we have delay in the justice system in both criminal and civil jurisdictions. And the CCJ went down on those courts for those. Some put 25 years. And we're not talking about a criminal one where they were in death row for, we well know the whole story of Bratton Morgan. Joseph and Boyce was actually a successor to that. So the cases, the guidance cases from 2019 and 2020 were my pet peeve. These were political cases engaged in the political strife and political fiasco in Guyana. And the CCJ played a phenomenal role in getting the Guyanese government, the Granger administration at the time, to step down when they refused even with OAS observers, even with calls from prime ministers, like Prime Minister Motley, Prime Minister Clinton, Prime Minister Ralph Gonzalez, our Vice Chancellor Sir Hilary Beckles, they were all calling on the greater government to do the right thing at the time that they refused. The CCJ judgment was instrumental in getting them to step down. So they engage also corruption in the local, in the political arena through this the case called Marine and Foy, which we had two government ministers actually purchasing land at less than 1 million less than its market value, and the land was actually sold to a company in which one of them had substantial shares. The CCJ was an interesting case because they had to engage the sole issue of whether this was going to be engaged as a civil matter, you know, as a lawsuit, or whether it was going to be engaged as a criminal. And they worked it out, and the judgment actually, I think, redounded to the benefits of the regional public. And why we argue that the appellate jurisdiction is important for foster regional integration is because the norms and the values that these decisions shape, that they reverberate across the region. When you talk about endemic delay in the judiciary, it is something that affects the entire regional public. When we talk about corruption in the public arena, you know, whether it's government or it's public service, this is something that we share. You know, when we talk about constitutional crisis, and even now we're hearing about one looming in Trinidad and Tobago, we're hearing about that, and it may very well erupt. Something to look out for. We political science are looking very, very carefully at what is going to happen in the transition from one prime minister to another, and whether that is indeed constitutional or whether it contravenes. So it's something that if Trinidad and Tobago subscribe to the CCJ, I would have reached there. Then definitely would have reached there. It probably would reach if it is addressed, if it is taken up. So you know, I love writing. It is actually my hobby amongst my many hobbies. Love writing, but I enjoy engaging in these political cases. With my background in political science, it gave me another edge in being able to do it. What was interesting is that the judges also over time went into the political history of Guyana in their decisions, which didn't just engage legal issues, but also political issues. You know, this was a matter that came up in Nicaragua and the US. When the US refused to accept the ICJ's decision on that intervention case in Nicaragua had intervened in, the US had intervened in Nicaragua. Nicaragua took the matter to the ICJ. And when the ICJ ruled, the US refused to accept the decision because on the ground that the decision was made on political issues and not legal issues. But, you know, I often ask my students of international law whether we can really separate them, whether we can really separate the legal issues from political issues when the matter is highly, highly political. So this is something we have to think about. I will leave you with that thought. And now with what I'm supposed to do as coach, well, a sport, not a sport, but as the chair. I want to welcome our first item. We have Ms. Gabrielle Simbu. She's a research assistant with the Department of Political Science. Very beautiful voice. I heard her sing for Christmas and I tried and I engaged her just a very short notice. And I gave her a choice of a song I wanted. And she said, you know, this is a very beautiful song, but she would need an accompaniment, particularly a male accompaniment, because it's a duet. Lying round one else, but before many talents, the man of many talents, to accompany her. So I'm now going to pass on to Gabrielle Simbu and Justice Anthony Buford. They're going to sing the prayer. And Professor Antoine, you know, it's always marvel that your voice singing Latin, opera singer. And he always wanted to be like Peter. Despite all the kids, there's a secret. Oh, so he decided to follow in your footsteps and sing as well. But very, very like that.
London. You choose that. London. London.
They had that each time because we did both of them at the same together. Okay, so, but we are sorry about this instruction, but we now move on to opening remarks by campus principal,
FM mode.
supervisor,
Bluetooth mode.
and
London
Professor.
mode.
So Professor Rosemary Bell Antoine is the principal of Louis St. Augustine. She's professor of labor law and also financial law. She also holds a doctorate in law from Oxford and LLM from Cambridge and LLB from UV. She's an attorney, award-winning scholar and author, the national consultant, temporary court of appeal judge and activist. She was elected president of the Inter-American Commission of Human Rights Washington, the only person across Trinidad and Tobago to do so. She has OAS rapporteurship on human rights Washington. Purpose of African descent and indigenous peoples, and was head of the OAS Economic, Social, and Cultural Rights Unit. She was CARICOM chair of HIV migration and the CARICOM Regional Commission on Marijuana. She's a president of the Family Planning Association, Cambridge Fellow, a member of Trinidad and Tobago's Industrial Relations Advisory Committee, an honorary fellow from the International Society for Trust Practitioners and Holy Caribbean Institute. This historic twice winner, the Vice Chancellor's Award of Excellence of Beauty for research done for public service. She has published 15 books and numerous scholarly articles. She was honored by the Cable campus as an outstanding alumnus in 2018 and as an eminent jurist pioneer in Caribbean women by the Caribbean Court of Justice in 2021. Served as a consultant to all of the governments in the area, UK, Venezuela, USA, Canada, judiciary, and international organizations, including the EU, OAS, IDB, World Bank, CDB, CARICOM, UNDP, UACS, UNICEF, ILO, UNIFEM, CARIC, ANCAP, UNAIDS, UNDCP, and ECNA. Drafting legislation and authoring influential of the thought-breaking policy reports on several variations, characterizing Caribbean legal development. She is described by governments and others as the foremost labor law expert in labor law in the region, the leading author in the region, international financial law and HIV law, and a change agent. Antoine is committed to development within the framework of human rights. She enjoys painting, gardening, and is a trained, classical, very talented singer. So I thank her. Good afternoon, everyone. Did you get yourself organized? Because
USB. Well, you have to go to oh, yeah, yeah. But where would you, you should plug it in.
see several dignitaries. I would adopt it for the protocol. Please allow me to single out our president of the CCJ. I think it's an appropriate occasion. Justin Saunders, who is about retiring, I'm not sure what's the correct thing. But not only has he been an outstanding jurist, but he's been a true friend of the University of the West Indies, and certainly of the faculty of law. And he go back home way, even when the first year students, when I was at Cambridge, he would take time to come and sit us, and that is really tremendous. One of the famous community and sense of service. And I really want to record my own appreciation as an academic, but also now as the principal of the City University campus. Thank you so much for yeah, that we launch of this very important group. Of course, I think I know I am more as the principal and not as the being responsibility, or even as the, as you heard, the supervisor. And I'm now getting one of the kids out of school. I wasn't aware I'm such a dragon, but that's okay. You are right, it's a lovely doctoral thesis. And I want to say thank you so much for inviting me to be here. It is always a special occasion. As a principal of this really wonderful institution, some of us have given it our lives. I am one of those. I don't want to tell you how long I've been with you. If time is ever be better some other. But you know, it's always a proud moment when our staff, and of course Indira is our head of department of political sciences, and Emmanuel was with us for many, many years as a part-time lecturer, associate lecturer, so he was with us to that. And when they get to the point where they publish a full work, a full scholarly work, a book, and of this magnitude and relevance, so I am very proud of the authors today, and this is that capacity that I speak, but also, of course, it's a topic about which I am quite passionate, the CCJ in general, and Caribbean legal development as well. And so I'm really happy to be here to support both of you. I couldn't miss it, although I hate to give up my weekends these days, but I thought it was worth the effort. And yes, as you would have indicated, I would have been there guiding as supervised sector and department for 3 years, and this is graciously acknowledged in the text, for which I'm also grateful. And it's a special sense of pride, I think, within you. I want to say something special about Indira, Dr. Ramprasad as well. Let us just say that we also know each other very well in a different capacity. And we have often tested, especially recently, the theories of conflict resolution, political science, integration, I think, a little bit of international relations, but I think all in all, Caribbean of the Little Month. Also, Dr. Harrison, all of which are sub-themes in this book. I do want to highlight those Justice Kapoor's perspective regarding his personal journey with the CCJ. It warms my heart that he started off a cynic. There are still many cynics about, but that he was transformed from detractor to someone with full support for the CCJ. So I think that gives us hope. I think most of us in the room would probably, at least at home, supporters of the CCJ and its potential for development, including regional integration, although that was at the time of the thesis and still is a very unique theme, because I don't know that we thought about it. Way politically in one of the very various facets that are covered in the book. And I want again, as principal and as a UB scholar, to say that for many decades, the Faculty of Law in particular has championed the vision of a regional court, providing very stellar arguments in favor of what is now the CCJ. But when I was growing up in the faculty, I think we should call it Caribbean Court of Appeals, that's what I forgot now. And then we decided to call it Caribbean Court of Justice. So that was a great moment for the university when in 2005, the court was inaugurated to put its original appellate jurisdiction. And coincidentally, you would have quoted from Dr. Henry, and whom I also know pretty well, and coincidentally, who was the lead prime minister for the establishment of the CCJ at the time. But more importantly, from my point of view, was a former lecturer in the Faculty of Law and also head of department. So I think it was a wonderful coincidence that he was one of the lead authors as well as then the lead prime minister. And I saw when you quoted those words, those very inspiring words of his in 2005, which are very often quoted, the leap to enlightenment. Those words which I think really continue to give us confidence, not just in the CCJ and in regional instruments, but it goes beyond that. It goes beyond just the legal sphere and really speaks to us as a people about our confidence in ourselves. So I'm glad that you reported it, and in reflecting on the court's 10-year anniversary, in a piece I wrote in 2015, the 10-year anniversary, I did recommend and continue to recommend that carry from countries that have not yet ceded to the appellate jurisdiction in Greece. I remember what that time we had, at this time I was here, at St. Augustine, having left the Cleveland Faculty of Law. We partnered with several international organizations, including ILO and on. There was a symposium on the CCJ, and what we did at the time was to feature jurists from the Commonwealth, from Canada, from Australia, from India, in order to urge the remaining countries to engage in the product session. It was called Advancing the Case for Regionalism and Indigenous Jurisprudence, Positive Dialogue to Promote the Accession to the Caribbean Court of Justice. Very long title, I'm sure I didn't use the title, but I don't like these long titles. But nevertheless, we knew how important this court would be, not only for regional integration, but to ensure fairness, justice, equity, and impartiality in the context of our own culture, norms, and values. And of course, a big point has always been the issue of access to justice. And I was rather intrigued because I have to look at the statistics that India gave the statistics a while ago. Because I can show you, if you compare between the original jurisdiction and the appellate jurisdiction, how many cases came for the original and appellate. That's not surprising in my view, because of the nature of the original jurisdiction, which is trade, etc. But I can assure you, if you were to compare the number of cases that went to the Privy Council in that time as opposed to the CCG, it would be a lot less. And that has always been one of the problems. So people cannot afford to go to the public courts. And it's very difficult to get, and increasingly so. So access to justice has always been an important point. So at that symposium, we wanted to dispel some of that doubt that Vice Chancellor Beckles, who was written the forward for this book, we wanted to dispel that doubt and to demonstrate how other Commonwealth countries had initially the same lack of confidence that we apparently still have, and timidity that we still display when confronted with the need for genuine self-determination that the CPJ represents. And it was very fascinating to listen to the Canadians and the Australians, and so they went through the same experiences, talking about, all the kinds of criticism we now hear. It's so interesting to hear them talk about. Of course, Canada is, as we speak, confronted with threats of recolonization, but nevertheless, that whole notion of self-determination is always something very important about the CCJ. And as a political scientist, one of the authors being a political scientist, I think these things continue to be important. I have found the CCJ, and I've written about it as well, to have developed a very rich and significant indigenous jurisprudence, which while adapting to our local circumstances, has not compromised appropriate judicial principle of the view of the law. And so I have no doubt that this critical work will not only further the conversation of the CCJ, but also contextualize in our political and colonial history and add a lot of depth, much needed depth to the discussion. In fact, I actually think that the discourse on the CCJ has declined somewhat. We're not hearing much about the details, and so we do need more work that's somewhat subsided. We need more scholars to be talking about the CCJ and to be analyzing the work of the CCJ. Also, what I like about the book, and it's something that I talk about a lot, and you read, is that it offers a multidisciplinary view. I very much value multidisciplinary studies, especially in today's world. I think we must, that is the future, and this book gives us that opportunity. Effectively marrying international relations to political science and international law, as it seeks to consider this question of regional integration. So I think we accomplished that in this model. So I did very much enjoy reading the book. I was very happy that I didn't have to take a red pen anymore, go through but seriously, yeah, it is a pleasure reading. It is a finished product, and of course it's more than the piece, it's a lot more than a piece. It's a piece, it's so much. And afterwards you go back, and then when you publish, you have a unique perspective at that point. And it does offer comprehensive analysis of the jurisprudence and its goal of fostering regional integration. And in here, what I've gone through a lot of what it's done, I'm not going to go through that, I'm not here, and Justice Saunders will be giving us a picture and rest with all the details, but suffice it to say, it does the job, and it clearly required considerable dedicated effort. And we note all of the research that you have done, very thorough, and all of the interviews with very distinguished and knowledgeable person, all of which gives credibility to the book. And I think the participation of such learned and esteemed individuals alone, that's a great signal of the value of the book and also of the CCJ. And I feel, of course, I think that in terms of the jurisprudence, there's some important messages there about human rights, or the most important cases coming from the court have been human rights and indigenous rights. So all of that is rather interesting.
And so I don't think anymore, that there's much doubt about the stability of this state and its importance, yet we cannot ignore the fact that although the arrangements for protecting independence and integrity among the times in the world, there continues to be some doubt about this division. We all know this, it's a work in progress. And so although the decisions have demonstrated that it is certainly not the same for governments, quite probably quite the opposite, in several decisions criticizing government in the region. We understand that the remaining messages of doubt and mistrust have to do with colonialism and our own lack of confidence in ourselves. As you observed, Dr. Ampersand, the CCJ stands as the beacon. It speaks to the deeper intellectual and philosophical questions of who we are and where we are going as Caribbean peoples on both. So I do hope that this work will continue to inspire, will achieve its objective, will motivate those remaining persons who are still on the fence, so to speak, countries, I would say, and persons, to jump in to embrace the point. And I do believe that the core question the doctor who asked originally, does the CCJ have the potential to promote unification? Meaning that I think it is well answered, and it will continue to deliberate. So I wanted to urge all of you to support the book, to consider these issues, allow these issues to resonate with you. And of course, I want to once again congratulate Dr. Ampersand and Dr. Ganpour, and thank you everyone for coming out to support the work and the
Thank you, Professor Antoine, Principal Antoine. I don't know if singers are ready. They get the microphone going. Because it's a UL, we need two microphones. See? So it's a little higher sophisticated IT level that we require. Are you ready? Okay, so I'll now pass on to Gabrielle Simcoe, our research assistant at the Department of Political Science, and Justice Dr. Andy. Oh,
Hello. Hello.
Bluetooth mode.
Hello.
just one. Help us to be one. In times when we don't know, let this be our precious. Friends are well. God is to a place where we'll be safe. In our hearts.
That's a being obscure.
You know, one of the things that was pointed out to us is that Caribbean scholars are not publishing a lot of Caribbean issues, particularly in CPG. And a lot of the scholarship is actually coming from outside the region. So we had gone to Denmark, and there were two guys there. There's a port called I ports. They only focus on international ports. And the head of the institution, Professor Manton, and one of his colleagues, Salvatore, they publish extensively on the Caribbean Court of Justice. And when I saw that extensive collection there, I thought this is nonsense, this is what we do. Just this is Caribbean resolution. And we have enough Caribbean scholars to do it. So we should be doing it too. So this brings me to our feature speaker, Justice. So Mr. Justice Adrian Saunders is president of the Caribbean Court of Justice. Justice Saunders, I would send numerous questions to when we finalize both the thesis and the book for points of clarification. I remember I asked him a question, stare decisis, and I said, justice but stare decisis is domestic law. You know, we don't have hierarchy of courts in international law. This is what I teach my students, and I see stare decisis appearing in the revised Picture grammars. I was totally confused. Can you explain this? And Justice Pollard in the top, and cited in Myrie as well. Perhaps Myrie is Barbados. So Justice Saunders would explain, you know, some of these concepts to me: binding precedents, binding decisions, compulsory and exclusive jurisdiction. And Professor Antoine pointed out to Justice Kafura, these are concepts we need to engage. These are the legal concepts you need to engage. But these are the issues that the CCJ is going to employ in the ratio of the cases. So Justice Saunders is also a pillar of strength and support, providing information whenever asked at short notice. And sometimes even engage when I need a quick answer, Justice Anderson. For some issues, he's unfortunately not here with us today. But I would like now to introduce the President, Justice Saunders, been with the court for 20 years, since it was inaugurated in 2005. So he's come full circle. You see, completed his circle of independence, and that was the name of Justice Pollard's book. He's also come full circle and about to retire. He is a native of St. Vincent and the Grenadines, who was a Bachelor of Law degree from the University of the West Indies, APIL, in 1975, and legal education certificate from the Newwood Law School in Trinidad and Tobago in 1977. He began his legal career as a barrister and solicitor in private practice in his home country. In 1990, he established the firm Saunders and Huggins before being invited to join the Eastern Caribbean Supreme Court High Court Bench 1996. On the 1st of May 2003, Mr. Justice Saunders was appointed to the Eastern Caribbean Supreme Court of Appeal and served as acting chief judge between 2004 and 2005. While at the Eastern Caribbean Court, Mr. Justice Saunders developed a passion for and was deeply involved in various judicial reform efforts. These included the introduction of court-connected mediation and the Eastern Caribbean development of the court's first judicial code of ethics. He also served as chairman of the Eastern Caribbean Judicial Education Institute from 2001 to 2004. His work in judicial education has continued with the Commonwealth Judicial Education Institute. He earned a fellowship of the Court of Justice, CJEI, in 1998, and he is currently, and has been for several years, the course director for the CJEI's intensive study program. He's also one of the institute directors. In 2005, Mr. Justice Saunders was among the first cohort of judges to join the CCJ. Mr. Justice Saunders has contributed greatly to regional judicial outreach and judicial education efforts. He's a founding member of the Caribbean Association of Judicial Officers, CAJO, and has served as the organization's chairman since its inception in 2009. Due to his active engagement in advancing judicial integrity, Mr. Justice Saunders has recently been appointed to serve on the advisory board of the Global Judicial Integrity Network by the United Nations Office on Drugs and Crime, UNODC, Global Program for the Implementation of the Doha Declaration. Mr. Justice Saunders' interests also extend to the area of court administration, where he has adopted an active role in the CCJ's public education and other strategic projects. He led the development of the court's first strategic plan in 2012 and currently chairs the ongoing project to develop and execute the strategic plan for 2019-2024. Mr. Justice Saunders has written many legal articles and publications and is a consultant editor of the Caribbean Civil Court Practice and co-author of Fundamentals of Caribbean Constitutional Law. He served as chairman of the Caribbean Association of Judicial Officers, which in collaboration with UN Women played a leading role in developing and promoting the adoption of gender-sensitive protocols for judicial officers for various Caribbean judiciaries. He also lectures part-time at the UEC University Faculty of Law and Constitution. At its 29th intersessional meeting in Port-au-Prince, Haiti, in February 20, the Caribbean Community Heads of Government agreed to the recommendation of the Regional and Judicial Legal Services Commissioner that the Honorable Mr. Justice Saunders be appointed President of the Court. He became President on 4th July 2018. The Honorable Mr. Justice Saunders is married to Marilyn E. Dawson, and the couple has 2 sons, Yuri and Yanni. Justice Saunders, you.
And everyone. All the important establish starting program. We belong to recognize all our centers. My sister, this is parents, Dennis, he's still online. Speaks, representing the industrial court. And let's see. And all our dignitaries, very special good evening to you. First things first, I don't know that we give sufficient round of applause to Anthony and Gabriel. If either of everyone I want to wish all women with us happy International Women's Day. Today is a day that we recognize and honor all our women. And we commit ourselves to eliminating all forms of discrimination. Your presence here, all of you, at this launch signals your interest in scholarship about the Caribbean People Justice. And for that, I experiment extremely grateful to see. I'm going through this publication. It is an excellent book by Dr. Amsa, Justice Kapoor, and I'm very pleased to offer remarks on this occasion. Since there was a feature of this, but this remarks. What I'm going to be very grateful in terms of CCD for a very long time. And I really appreciate the writing of this book. It seems to bring, as Dr. Anthony said, the level of enlightenment to what CCD is about. As you heard, the publication of the book at this time has an added significance because the court celebrates its 20th anniversary on the 16th of April, just next month, a 2 days time, 2 weeks time. 2 decades, 20 years, provide a fair span of time to assess an institution, to assess its administration, to assess its jurisprudence. And I think that works like these that try to make that sound assessment very valuable for us. And I trust that more acclamations will follow suit. There's probably more written about the CCG outside the region, from authors outside the region, than there is from persons in the region. And that is totally respectfully that extra-regionally the court has attained and It also says something a little different about us in the region. We won't go there yet. In the first introduction, in the introduction chapter of this book, the authors rightly touch on what some might consider to be a pervasive cloud that hangs over the CCJ and indeed all our regional institutions. And that is, the phrase that they use is a very potent tension between nationalism and regionalism in Canada. It has existed quite some time and it continues to exist and to threaten and to thwart efforts at closer integration. It is a pervasive tension that ultimately proved to be one of the causes of the unraveling of the West Indies Federation after just 3 years or so. There was a famous referendum in Jamaica in September 1961. As a result of 54% of Jamaicans voted to exit the referendum. That was followed by Jamaica withdrawal from a 10-member referendum. That was followed by the even famous act of the Honorable Prime Minister, Chief Minister of Trinidad and Tobago, one from $10 billion. And then there was the collapse of the depression. Regionalism and fascism proved that when you consider that, ironically, precisely at the time that Jamaica was going through its referendum and then preparing to become a nation state, Trinidad likewise, precisely during that time, when nationalism was at its height, the West Indies cricket team, under its first non-white captain, Lynn Frank Warren, was playing the best cricket it had ever played till then in Australia. West Indies 1961-1962 tour of Australia is still considered to be one of the greatest test series ever played. Matches were played in a superb spirit of camaraderie. Each of the 5 tests was very keenly contested, and the series, which was narrowly won 2-1 by Australia. If you listen to some of the Caribbean, they will tell you about the empire and so on. But it included first ever tied test. And at the end of the tour, the normally partisan Australian crowd gave the West Indies team a send-off, the likes of which had never, ever been seen since then. Nor has it been seen subsequently. They had a ticker-tape parade to the airport. So on the one hand, you have Caribbean countries pursuing nationwide, becoming independent. On the one hand, the other hand, you have the West Indies team being playing best ever cricket they've ever played together in Australia. That is the kind of tension that is spoken to in the book. Despite the dissolution of the Federation and the fervent nationalism that gave rise to, the impetus towards regionalism, towards integration, was not lost, because Caribbean leaders lost no time in establishing first Caribbean Free Trade Association, CARIFA, and then Caribbean Community in 1973. And these intergovernmental bodies have spawned or lent their imprimatur to several regional institutions of which Caribbean people can take immense pride. Even though too often we simply take their existence for granted. These are institutions in which various states in the region pool their resources and ultimately produce an entity that is far more effective and far more worthy to the Caribbean people than anything that could have been undertaken by any single scheme on this field. University of West Indies, which is the venue for our activities today, is one such institution. Established in 1948 as College of the University of London, you regained full university status when in 1962, same year that Jamaica and Trinidad independence. At the last Sense of Government Conference 2 weeks ago in Barbados, CARICOM heads enthusiastically supported process of replacing the royal charter that establishes and governs the operations of UWI with a regional guardian treaty. So you have colonization still going on in the region where the royal charter, which currently governs the operations of the UWI, and which frankly is a nightmare to change because it's not ours. In order to alter it, and after 14 years from 1948, there are significant respects in which you want to think, repair, change this, change that. We can't do it because it's not ours. It's an English document, but thankfully there is no recognition, or not just a recognition, but there is a move to alter that and to replace it with a regional treaty. Caribbean Development Bank is another important regional institution, established in 1969 to support economic growth and development of Caribbean countries. When I was at the GCE, General Certificate of Education, which was done by London and Cambridge, we have now Caribbean Examinations Council. That too is a form of organization for reclaiming our own sovereignty, of pursuing our self-determination, of doing for ourselves what hitherto Britain did for us. All of these regional bodies that I speak of, and there are a number of others, they share a deep and unbreakable bond with the CCG. Because as I said, they're all initiatives that help us to deepen our regional pride and that further our self-determination. They're all very important bodies. But from my perspective, the most consequential of them all is the Caribbean Court of Justice. Because, I must point out, it functions as a supranational body of coercive powers over the CARICOM states. And this is remarkable. And I read somewhere, might have been in this book, that maybe when CARICOM as a government established the CCG and gave it the authority that it did, they really didn't recognize that all this skittishness that they continue to claim that they have about sovereignty, that they have let in kind of a Trojan horse. Because the Caribbean Court of Justice has been in power, or maybe they didn't. Maybe this was their attempt to ensure that what they publicly claim that they do not wish to do, that they would simply quietly have it done. Namely, to have a body that can issue coercive orders to regional states. And the CCG has not been shy to do that. In a number of cases in our original jurisdiction, CCG has made orders that particular states should take particular acts. All of those orders have been, all of them have been complied with. What that says to me is that the rule of law is alive and well in the Caribbean. Because you have a court which does not make these orders whimsical or likely. They make them after hearing very serious arguments. They make them after very profound deliberations. And when they make those judgments, even though sometimes those judgments are very bitter pills for a government to swallow. In one instance, we made a judgment in the appellate jurisdiction that resulted in a government surrendering power and accepting that it had lost elections. In another case in Barbados, this case was very interesting because the court ruled that the state of Barbados and the electoral machinery had to register nationals from Commonwealth countries, and in particular from the Caribbean, who were living in Barbados and who were entitled under Barbados constitution and laws to vote in the elections. Well, then Prime Minister Barbados did not like that ruling, and he railed against it. And he said that elections were like following week, that if his party won the next elections, he was going to trigger the process that would result in Barbados withdrawing itself from Caribbean Court of Justice. Well, I never appreciated that the court in Barbados was so respected, admired, and loved as when he made that statement, because all the talk show programs were flooded with condemnations of that statement. All the social media was replete with statements of support for the Caribbean Court of Justice. And guess what? We lost the election. We lost every single seat. Now, I am not saying that he lost every seat because of the state. There must have been something that's going on about it. But he lost every seat. And so, the countries in the region that know the CCJ best. See, people ask you, well, there's all this self-doubt, lack of confidence in the CCJ. There are two sets of countries in the region. There are those countries who know the court because we do their appeals. And we don't just do their appeals. We operate with high technology. This is not a boast, this is a fact. So all our appeals are live streaming. You have a computer with internet connection and you're interested in the case, you can see what is going on in that case. See the arguments, questions of the lawyers, of judges, the response of counsel, then judgment things is done. I have a household base in Ghana, in Barbados, in Belize. Any of our judges walk down the streets of any of those countries, people recognize them instantly. They come up to you and they speak about some case that they listened to. That is not the case in Trinidad. People in Trinidad don't know the court. They have no clue about the court. We had an occasion one time where we had a function at the court. And a minister of government of Trinidad and Tobago came to the court and didn't know that the court was important in Trinidad. So you have this duality going on between those countries who know about the court And who, because they know what the court, no longer have all of those reservations and feeling of lack of confidence that exists still in many of the countries where the court does not interface as regularly because the people don't send their appeals to the court. You know, the idea of a regional court, a regional Caribbean court, it started in 2005 when the CCP was inaugurated. In 1919, as is pointed out in this book, there was a regional court, a court of appeal that embraced Trinidad and Tobago, Leeward Islands, Grenada, St. Vincent, Barbados, British Guyana, a single court for all of these countries, which still had appeals from that court to the council. In 1958, when the Federation started, you had a federal Supreme Court. Although Guyana did not join the Federation, Dr. Chenjiga figured that that colonially imposed structure you all have there, that is going to be another colony, and he kept out of the Federation. But Guyana joined the Federal Supreme Court. And authors, like did so, rightly noted, quoted John Mordecai, Jamaican, wrote a book about the Federation. And he said about that court, the eminent quality of the court, Federal Supreme Court, set a new standard for superior courts throughout the region. When the Federation was dissolved, it left a huge void. Point I'm making is that regional courts, long before the CCG was established, have shown their mettle, their competence, their ability, and the idea of still being uncertain about whether we have the legal acumen, the capacity, the wherewithal in order to staff a court and to run it, something which is long ago proved to be not the case. It's not just a repository and an adjudicator of disputes. And that's one fundamental differences between the Caribbean Court of Justice and the court like the Privy Council. Privy Council sending out an appeal and you get it right. That is the extent of their interface with the Caribbean. In London, send in the appeal, you argue it, you get a result. That ought not to be the full function of federal court. A federal court of appeal is a court that needs to interface with the courts below. The judges need to have regular seminars with the judges below. They need to be able to monitor and to evaluate the processes that are taking place in the courts below. They need to set a good example for the courts below. They need to have a finger on the pulse of what is happening, not just in the courts below, but in the society at large. And that is what the Caribbean Court of Justice seeks to do. And it has particular vehicles through which it does that kind of work. Through the Caribbean Association of Judicial Officers, which it has helped to establish and which it provides logistical support for, and also through the CCJ Academy Forum. The court also handles all of its non-adjudicative administrative matters, including its financial, human resources, communications, logistics, IT training, security issues, and so on. The price of that very welcome economic independence is the necessity to undertake enormous responsibility. And so the court and the commission, the Regional Judicial Legal Services Commission, have placed very great emphasis on the development of internal mechanisms to optimize good governance and strategic direction. So, as you heard earlier, we have 5-year strategic plans, which serve as dynamic tools that guide us in improving from year to year, from strategic cycle to strategic cycle. In other words, we don't operate by halves. We have a strategic plan and we follow that plan. As the region's apex court, the CCJ is conscious of its obligation to set high ethical and operational standards that provide that example for the courts below. We have developed a raft of policies to govern various aspects of court administration and staff and judicial conduct. You go on our website, if you want to make a complaint against a judge, you can go on the website and see how we go about making that CCJ is not afraid of a complaint, opening up itself to public scrutiny. Notable policies of relatively recent vintage include the third iteration of the Judicial Code of Conduct. Every 3 or so years, we look at our Code of Conduct and we look at the ways in which it needs to be tightened. Last iteration, we have these regulations that I said allow for persons to make a complaint if they feel that the judge has done something which is unethical. We have a harassment policy. We have a policy governing access to justice for persons with disabilities. When we deliver our judgments, we ensure that we have someone who is able to sign so that the hearing impaired can hear what the judgment says. And we have a policy on the use of artificial intelligence. We also have a tool which for now is only used by our internal stakeholders. It's called Ask the CCJ. It's an AI tool. And we have fed into this tool all the judgments of the court, all the speeches of the judges, all the rules of the court. And so our judicial counsel, our judicial researchers, if they need information about research on the court, we can type in question and we get the result. So we try to keep up with the latest in technology. And of course, our commission plays a very huge role in ensuring that the financial prudence of the court, the administration of the court are all done in a way that makes the region proud. The main challenge faced by the court is, of course, the modest uptake in cases in the original jurisdiction. And the reasons for this are varied. not a lot of lawyers in the region are well versed in provisions of the Revised Treaty. And so they're often not particularly alert to raise with their clients opportunities that might arise for their clients to pursue disputes that they might have with governments or states that might be in breach of the treaty. Municipal judges also, judges and magistrates, have not been referring any of the few cases that have come before them that touch and concern the treaty. To try to address this problem, over the last 2 years, Court has been holding a series of seminars with the stakeholders and with the business community in order to explain provisions of the treaty and the rights that it gives to Caribbean nationals. In the appellate jurisdiction, question that everybody asks is, but why only 1/2 of the eligible states have acceded? And again, here the reasons are varying. And one of the important reasons is that in some countries, there are extraordinary constitutional hurdles to overcome. In Grenada and Antigua and Barbuda, for example, in order to accede to the court, you must have at least 2/3 vote in parliament and 2/3 vote at a referendum. On 2 occasions, Grenada tried, we had the 2/3 and more vote in the parliament, but it's very difficult to get 2/3 at a referendum in a politically charged country where the opposition could seek to exact a price for its support for a referendum. Antigua itself also tried, but that referendum, that process also failed at the referendum. In Jamaica, where the Constitution does not ostensibly require a qualified majority vote of the parliament, Jamaican parliament passed the necessary legislation. It was challenged. Trial judge thought that the challenge ought not to succeed, could have appealed, considered the matter, and thought unanimously that the challenge ought not to succeed. It becomes so different, and it implied into the Constitution the need for at least qualified majority. So, in some respects, countries that have been willing to come on board have been thwarted, have been set back as a result of the Privy Council and as a result of constitutional mechanisms which were placed in the independence constitutions that they have difficulty implementing. The most important roles of a final appellate Caribbean court are to protect and advance democracy and the rule of law, to develop the region's jurisprudence, and to expound countries' constitution. In fulfilling those roles is often necessary to tackle difficult or great areas of the law, to weigh and to settle one of almost equally persuasive contemporary rules. Appropriate resolution of these great areas requires judgment, requires an element of judicial policy making. Now, it's not mathematics. Interpretation of a constitution cannot be divorced from the social, environmental, and cultural context, and a deep appreciation of the historical roots of the country's constitution. Judges who are naturally alienated from the pulse of the society, from the narrative that guides and animates that society, and moreover, who do not personally experience the consequences of the decisions they make, are not very well positioned for binding prescriptions for that society, to govern that society. The region needs regional judges to finally adjudicate the region's disputes. If there is a dispute in Britain, best judges to adjudicate that dispute are British judges. If there is a dispute in France, best judges to adjudicate that dispute, French judges. In the Caribbean, our disputes, best judges to adjudicate those disputes are Caribbean judges. And this is something which is a no-brainer. Something that is recognized all over the world. It's only in the Caribbean and Mauritius that you have your final appeals being outsourced to be heard by a body thousands of miles away across the ocean. It's a state of affairs which we should regret and do something about as soon as possible. So it's therefore important that Caribbean academics make impartial and informed assessments of the court and publish their findings, that they interrogate the court's judgments, and that they illuminate the darkness by shining a spotlight on an area of Caribbean life that could certainly benefit from something like it. And that is the value of this group. I want to congratulate the authors for publishing the book and for the meticulous research they've done. They've done something which is extremely challenging and interesting, and that is to find the connections between the role of the court in its treaty jurisdiction, in its original jurisdiction, its jurisdiction where we interpret and apply the CARICOM Treaty, to find the connections between that and the role of the court as a final court of appeal. And I thought that that was a very ambitious path to follow, but it is an important path because the two cannot be connected. You can't be creating a Caribbean community, single market and economy that does not have rules that are common so far as institutional interpretation is concerned, so far as contractual dispute settlement is concerned, so far as the rule of law is understood and applied. And it is in the appellate jurisdiction that many cases deal with those issues. And so I close by again warmly congratulating Dr. Bamsad and Mrs. Kapoor for this splendid effort. And I know that this is great. Thank you very much.
Thank you so much, Justice Saunders. I'm listening to you, and a lot of what you said, entered our mind so many times. The whole notion of a lack of trust and confidence. And I presented a few weeks resist on the perception and misperceptions of the Caribbean Court of Justice, because I think a lot of that has to do with misperceptions. It has to do with misperceptions, irrational. When we interviewed Mr. Pandey, it was a few years ago, for the thesis, and I said, Mr. Pandey, to tell me, why don't you support subscribing to the CCJ when you were the Prime Minister, at the time, the court was formed in 2001. And you actually fought to have this court in Trinidad and Tobago, that in Jamaica was also affected with the seat of the court. Is it that you really don't trust the judges? What is it? And Mr. Manning, his usual play, I said, he said, but it's not that we don't trust the judges. I said, so what is it? You don't trust court. What is a building? Okay, what is a building? So you don't trust the judges. He said, no, it's the perception. It's the perception that you can't trust it. I said, so you're basing a decision on perception. Does that make sense? It's irrational. You say, well, a lot about Trinidad is irrational. I said, but Mr. Mbate, I'm trying to get a rational response from you. I said, when I could write that you have said this, it was very, very difficult to put it down. But you know what I realized? That the emotions are so high. There is the dynamics of ethnicity, class, and even gender. And the joke, and ethnicity and class, I think, speak for itself. The class dynamic speaks to, many believe that this is an elite court. And when you talk about people who don't know about it, it has to do with the fact that there's no appellate subscription in Trinidad, but it also has to do with the fact that many people, if you go and talk to people in the streets and ask them how they carry court of justice, most of them don't know. My students didn't know. When I started to teach them, and with single market and economy, and I had a module on the CCJ, many of them are not good. And these are university students, second and third year students. They didn't know. So you can imagine about job out there. That's one issue. There's a lack of education, lack of knowledge about the court. But that issue, this sort of lack of trust and confidence, I don't think, and I don't like to argue about colonialism dimension too much. But I think it also has to do with a misperception that the court is plagued by some of the same challenges as the domestic judiciary. The people, there's a perception that the domestic judiciary is not upright, it's not above board, it's not right. Yes, the appellate jurisdiction is part of the domestic judicial system. People don't understand that. So the original jurisdiction is international and international, guided by international law, RTC is regional law, international law. But the appellate jurisdiction, you have to pull from many domestic jurisdictions to make decisions in those cases. So I think there is that lack of trust and confidence. They also believe that the lawyers who are going to the Privy Council are the ones who benefit most from this. And that is a middle class phenomenon, this whole idea of courts. CCJ, Privy Council, courts on the whole, is a middle class phenomenon. So the average person, unless they have a case in a court and not particularly interested. You mentioned the challenge of the constitutional majority. So it was brought in Jamaica and brought in Grenada, never been brought to Trinidad in the parliament. We need like 3/4 in the House and 2/3 in the Senate. Do I have it right? Yeah, 3/4 in the House, 2/3 in the Senate. We have the senator here, head of government, head of opposition business. So it's never been brought. This current government had it as part of their 10-point plan in 2015. That was there in the manifesto. And this current government is up in second term about it. And that matter has not been brought. So we don't even know, we don't have referendums anymore. So referendum is our best, it's not part of the constitution. But it was never brought by any government. The opposition brought it from Mrs. Kamal Service as I wanted that seated. Criminal matters, not civil matters. And the regional leaders have come from the RPC speak to accident both, so they shut it down. But maybe should have given it a chance with criminal matters. We have to start somewhere. So I don't think it's a mistrust of the judges, the gender dynamic, there's one female judge and there's always been one female judge. There's only one female judge in the Privy Council too. There's only one female judge in the Privy Council as well. So I don't know how that is played. We talk about ethnicity, we have 13 countries. We have 7 judges. All the countries cannot get a judge. We have an Indo-Trinidadian independence where there was a struggle for that, there was a complaint about that, there was chastisement about that. I think it was 2018 we got Justice Peter Jamada on the bench. I'm talking about perceptions, real, or imagine, these are perceptions that you're not going to get justice. But what I argue, I don't know how convincing you are. Okay, if you don't trust the judges, they don't look like you don't believe they're going to be fair, then just read the judgment. Just read the judgment. That's all you need to do. And see if you find evidence of bias. If you can find evidence of bias, bring it to me and I will raise it and I will write about it. And people are not reading the judgments. The people who are making comments about the CCJ, its fairness, its potential to be fair, who lack trust and confidence in the court, are not familiar with the jurisprudence. When you read those jurisprudence, I had my doubts about the court initially. Justice said he wrote about it. He was supporting the city council in his 2 days.
So,
But when
okay,
you
so he's hearing
read
in
the
dear.
judgments, you may not agree with every decision. We all have different backgrounds, different personalities. You may not agree with the
I'm
decision.
hoping he
Can you convincingly say that this judgment is biased? Can you convincingly say that? No, we couldn't find it. I was looking for that. When we were doing the research, we were looking for it and trying to understand this lack of trust and confidence. Actually, that is going to be the subject, that's going to be the subject of the next book, the Soul Privy Council CCJ debate. It's a revolving one, it's a rotating one, comes back and forth, will come back. Because it wasn't Mrs. Kamla Prasad who had said right here at the University of the West Indies, when the Faculty of Law was going to be inaugurated, that accession to CCJ is inevitable. It's inevitable. That is what she had said. So I think there is that recognition, because I'm not sure they're going to keep us. I'm not sure the Privy Council going to keep us. I don't know how much prestige they get out of this. I don't know what they know. But we're not seeing an outcry coming from Britain. Went to the British Library, I was looking for that, researching that aspect of it. How do the British people or the UK population perceive the Privy Council as a final court of appeal for these Caribbean nations? And that there's not much literature in it. There's not a controversial issue at all. There's not much issue there. But maybe sooner or later they will want to know. Sooner or later they will rise up, especially in these dire economic times. So with that, we're going to start with something a little more relaxed. We have 2 dancers with us, Valeska and Jelly Bahamut, and they are going to do a performance. Wonderful. So we welcome dancers.
Reminds us.
Okay, we're coming close to the end. Now we have the second president of the Caribbean Court of Justice. The first was Justice Pilar-Lee. Unfortunately, in 2024, we lost three of our judges, Justice Pilar-Lee, Justice Witt, and Justice Pollard. I think all. But that's a regular, yes. I think Justice Pollard went before. The court actually is now going to have virtually a new bench soon, very soon, with the departure of Justice Saunders' retirement. And we're going to have probably another 2 or 3 retirements soon. So it's going to be a completely new bench just now. We have Sir Dennis Byron, who's been from the very start of this very patiently waiting. Justice Kufura and I engaged Sir Dennis probably more than anyone else for this research. We spent hours on end over lunch, we would talk to students about the court, about the cases, about the whole Privy Council, CCJ controversy. And students was always worked with him to the point that students is now just a friend, a very, very good friend of both of us. He was here recently for an ADR conference and we had the pleasure of taking him around. I was in St. Lucia not too long ago and I actually met with him and his wife for dinner. So, Sir Dennis, he is also cited heavily because he would have spanned that, most of that period that we engaged, 2005, he died in 2018. So Justice Saunders, yes, that's when Justice Saunders came in. He died in 2018. So a lot of the cases were under his presidency. So with that, I want to ask Dennis to bring us some comments. Dennis, I hope you're hearing me because I know you
Well,
are.
thank you very much.
Okay.
I
He's
hope
on
you
the
can
line.
hear me and
Dennis
see me.
is currently based in St. Lucia, so he's on Zoom.
Yes, can you hear me?
We need to hear Sir Dennis.
Yes, because the reception has been on and off, but I hope you can hear me now. Because
Dennis, are you muted?
hello?
Yes, we're hearing you now.
Thank you. Yeah, well, I think it's a privilege for me to join in the celebration of a truly outstanding contribution to Caribbean legal scholarship. But I must say it is also a great pleasure to do so, because I recall the beginning of the journey which produced this work during my service at the Caribbean Court of Justice. And it is a wonderful feeling to see the culmination of this endeavor and the wonderful fruit that it has borne. So I know it's been a long day and I not that much time has been allotted to me. So let me move quickly to the main point, I think. I would like to extend my warmest congratulations to the distinguished authors, Mr. Justice Anthony Gafford and Dr. Indira Rampersad. They've exhibited great discipline and dedication because while they were pursuing this monumental work, they were discharging their normal professions with undiminished zeal and excellence. Both bring to this work the depth of their respective fields of political science on the one hand, and law and justice on the other, merging their expertise to produce a scholarly contribution that is both rigorous and insightful. In doing so, they have enriched not only their own intellectual horizons, but also the broader legal and political discourse of our region. This book serves as a powerful reminder that the pursuit of knowledge extends beyond adjudication and political analysis. It deepens through critical reflection, rigorous inquiry, and academic engagement. You've heard bits and pieces of their work over the course of this afternoon. I would describe it as a masterful exploration of the original and appellate jurisdiction of the Caribbean Court of Justice. While these two facets of the court's mandate are often studied in isolation, this book examines them with broader legal and institutional framework, one that is essential to understanding regional integration and judicial development. By offering such a thorough and nuanced analysis, Dr. Rampersad and Justice Gafford have provided an indispensable resource for jurists, for scholars, policymakers, students, and everybody who is interested in these subjects. I think that beyond its substantive legal insights, this book is also significant for another very important reason, about which I have commented on many times in the past. It reinforces the critical importance of Caribbean scholarship on Caribbean institutions, produced by Caribbean scholars and jurists. Too often, our legal and institutional narratives are shaped by external voices. This work stands as a bold statement that Caribbean jurists and scholars are fully capable of defining, analyzing, and documenting our own legal evolution with both depth and authority. I think it's a testament to the maturity of Caribbean jurisprudence and the growing intellectual legacy of the CCJ. It is also a bold example, which I hope will have many followers. The work, I'm sure, will be of great value to law and political science students throughout the Caribbean, as well as to academics, jurists, legal practitioners, and policymakers. But its relevance extends way beyond these audiences. Even those outside of these disciplines can benefit from its insights as it explores fundamental aspects of Caribbean integration, legal evolution, and political development. It also invites deeper reflection of the value of the Caribbean Court of Justice, both as a final appellate court for nations that have embraced its jurisdiction and as a pivotal legal institution shaping the regional legal landscape, including for those jurisdictions that are yet to take that step. This work has the power to influence thought on critical areas of Caribbean jurisprudence, challenging us to engage more deeply with our legal institutions and their evolving role in regional governance. Dr. Rampersad is a distinguished political scientist, and she has brought invaluable academic guidance to this work, ensuring that it meets the highest intellectual standards. Justice Gafford, with his wealth of legal and judicial experience, has seamlessly bridged the worlds of adjudication and scholarship, demonstrating that judicial thought continues to evolve beyond the courtroom. I must add, on a personal note, that I take immense pride in this achievement. This book is more than a scholarly work. It is an invitation for deeper engagement with our legal institutions. It's an encouragement for more Caribbean jurists and academics to document and critically assess our jurisprudence. And it is also an affirmation that legal thought in our region continues to evolve in meaningful ways. To the authors, Dr. Rampersad and Justice Gafford, and as Dr. Rampersad mentioned in introducing me, we have developed a close relationship. So I should say to Indira and Anthony, your contribution will resonate far beyond this moment. I commend you both for this extraordinary achievement and encourage all present to deeply engage with the insights it offers. I hope that the work will have a great readership, and I'm sure that any who reads it will benefit. And I certainly have no hesitation in encouraging its purchase. Congratulations once again, and thank you.
Thank you so much, Sir Dennis, for your kind words. It's really appreciate your presence. I know you haven't been able to hear everything, and this is going on for longer than we expected. But you have really contributed so significantly in our interviews with you, both formal and informal interviews with you on the CCJ research for the thesis and the book as well. So, Sir Dennis, thank you so much. We're just going to have a reading. I asked Justice Kafur to be brief because time is getting on, and this is the penultimate item on the agenda. So Justice Kafur will do a brief reading, and it is traditional to do a reading of the book in book launches. So that's why we're having it, although so much been said about this book before. So, and I'll pass on to Justice Kafur.
Very much.
So no book launch, I think, would be complete without at least a short excerpt from the book itself. And I think that, of course, it is indeed a privilege to just share with you some of our thoughts as reflected in this contribution. So I'm just going to focus on what is essentially chapter 4, which focuses on the original jurisdiction, and a lot has been written about this. But I start off by saying that the chapter examines the jurisprudence of the CCJ's work in its original jurisdiction in order to explain how the CCJ can foster regional integration. This will include a discussion on supranationalism, binding precedents, binding decisions, and the compulsory and exclusive jurisdiction as they relate to the case law, as these are fundamental premises upon which the CCJ aims to foster regional integration. This also entails an analysis of the attempts of the CCJ to uphold the pillars of regional integration as evidence in its case law, particularly with regard to the free movement of goods and the free movement of CARICOM nationals. It also includes an analysis of the economic and non-economic integration of the second generation new regionalism and the goal of the CCJ to further develop the Caribbean jurisprudence. So this chapter goes on to examine some of the leading cases, one of them being Hummingbird, Rice Mills, and Suriname, where the CCJ granted special leave to begin proceedings arising out of the non-imposition of the common external tariff on the importation of wheat or meslin flour into Suriname. Of course, we also had other leading cases that were explored in great depth, one of them being release of beverages, juices in the state of Guyana, where the CCJ held that Guyana breached Articles 78, 79, 87, and 90 of the revised Treaty of Chaguaramas, in imposing an environmental tax on Suriname, which exported beverages to Guyana on a non-returnable plastic containers. So the chapter goes on to point out that the CCJ also has the potential to foster non-economic integration. And I think this is an important concept because sometimes we think of integration in primarily economic terms. But of course, the theory of the new regionalism helped very much to explain its work. So several of its cases in the original jurisdiction seem to be more inclined towards non-economic regional integration, which is akin to functional cooperation as underscored in Article 6.1 of the revised Treaty of Chaguaramas. And functional cooperation, of course, also includes social integration, such as reflected in the cases of Myrie in Barbados, Tomlinson in Belize, and Trinidad and Tobago, which are primarily immigration type cases, and then Douglas and Dominica, Gilbert in Barbados, Spain and Trinidad and Tobago, and there are other cases as well that are relevant. I mean, the idea of supranationalism has been hotly disputed by some scholars, but what this chapter points out is that the phenomenon of supranationalism can be discerned through the principles espoused by the CCJ, as well as through its show of autonomy, authority, and independence over member states, and that the concept of supranationalism emerges through its authority in interpreting the RTC. This authority is particularly notable in its exercise of its jurisdiction, determining who should be granted special leave to bring matters to the CCJ pursuant to Article 222 of the revised Treaty of Chaguaramas. Through its legal competence in establishing the standard of proof required of the applicant seeking special leave to Article 222A and B, through its jurisdiction in deciding on the application of the intervener pursuant to Article 208 of the RCC, and Article 18 of the agreement establishing the CCJ, and by applying certain principles and precedents established by other international courts, such as the ICJ and the CJEU. In particular, what the CCJ has done, as the chapter points out, is that it reflects the ability of a private party to directly access the CCJ as being a phenomenal development in Caribbean jurisprudence. And of course, interestingly enough, although we've only had one matter to date being brought, I think, by a state, others have come to the CCJ by private entities, which are either companies or corporations or by individuals. And so therefore, the most popular source of litigation has tended to be through private party litigation. But notwithstanding that, many of the states have an interest in these cases as well, as has been pointed out by Justice Saunders. So the CCJ's supranationalism surfaces through the powers conferred upon it by these instruments to permit these entities to espouse claims which their member states have decided to support or which their member states have authorized. And the chapter goes on. I'm not going to go through all of it, I think, in the interest of time, but I'm going to turn fairly quickly to the conclusion arrived at in that chapter, which points out as follows. In chapter 4, the book focused on the jurisprudence of the original jurisdiction of the CCJ, which is examined in the context of its expressions of supranationalism, with its concomitant doctrines of binding precedent, binding decisions, and as mentioned before, the compulsory and exclusive jurisdiction. These are all critical concepts in terms of understanding how the CCJ functions. And in analyzing the case law in the CCJ's original jurisdiction in chapter 4, the book affirmed that it is the authority conferred on the court by the RTC and the very member state which so jealously guard their sovereignty, which empowers it as a supranational entity. You would have heard Justice Saunders referred to the concept of the Trojan horse, an idea that was born out of the pronouncements, I think, of Prime Minister Ralph Gonsalves. It also contends that the CCJ's jurisdiction to grant special leave under Article 222 is role in determining the application of the intervener and Article 18 of the agreement, protection of correlative rights. In part 3 of the RTC, competence in determining the standard expected of the applicant are integral elements of its supranationalism. And so the book goes on to cite several instances where the CCJ has bound itself to its own precedents in its original jurisdiction. And it also demonstrates, I think, as we've tried to illustrate, the extent to which the CCJ has referred to its compulsory exclusive jurisdiction, its original jurisdiction. And there was a query on this raised by one of our very, very great scholars of the past, Professor Ralph Carnegie, in this regard. And this provision suggests that matters pertaining to breaches of the RTC must be taken to the CCJ with the implication that there's really no other recourse. And so the CCJ clearly privileges the regional integration agenda by insisting that member states fulfill their obligations to ensure that their domestic laws are in sync with community law, as this is critical to the uniformity, stability, certainty, and predictability, which are essential ingredients for advancing regional integration. At the same time, we think the CCJ has been careful not to assume jurisdiction where it had none, such as where the appellant was neither an organ nor a body of the community, nor an integral part of the community. So I think with these few words, hopefully it gives you some sense of what the book has tried to talk about, explore. And you know, as this chapter comes to a close, one of the things that was pointed out is that the CCJ has demonstrated that it understands well its role as guardian of the RTC to uphold the rule of law and the rights and obligations created by the treaty. Thus, as a non-state actor with supranational powers, the ideas espoused by some theorists call neo-functionalists blended in well with this bottom-up approach to regional integration and the multifaceted perspective of the second generation new regionalism. Tremendous autonomy, authority, and independence exemplified by the CCJ, the caseload's original jurisdiction suggests that the court is well poised to drive the regional integration process. So I think that I will conclude my excerpt there. Permission.
You, Justice, for being brief and for bringing the issues to the fore. That was the whole idea of exclusive and compulsory jurisdiction, you know. So you're telling the court you can't go, and you're telling the states that you can't go anywhere but to the CCJ as compulsory and exclusive jurisdiction in the original jurisdiction. So it's not been tested that one of the states decided to up to, let's say, the World Trade Organization, they have a tribunal there. It's not been tested, so we don't know what will be the penalty. It would be a breach of the RTC. They should go to another tribunal, or would it? Just as well as something to think about what would happen if a state upped to not going to the CCJ. And we have had, I think, one state bringing matters. We haven't had many matters coming from state against states and state. This in itself, to some extent, speaks to regional integration because it means that our states are not prepared to litigate against each other. But we do have Article 222, and I think that is one of the most powerful expressions of the CCJ's supranationalism. That's allowing individuals to bypass states. Individuals and private entities, companies and corporations, to bypass states. You don't have to go to the government. You don't have to go to the government. You come straight to the CCJ. And even the poor, they have heard cases in former corporates where poor people can access the CCJ. CCJ offered them legal assistance and through video conferencing and whatnot. They don't need to travel. So we had, I think it was Elizabeth St. Clair. I think that was the case, Corey. Yeah, that was the case where these two poor Guyanese nationals were able to access the case, the CCJ, without having to spend tons of money, which they didn't have. So it has been pretty facilitated for the regional public, and that itself would speak to its attempt to bring the people of the region together. We went about to close, and we have one last dance, after which I would want to invite you to reception. We have some snacks and drinks, which we'd like you to partake after this dance. The book, I know some of you are wondering where you can get it. So we've had some mishap because the book was published by Palgrave Macmillan, and the distribution was left to Springer Napier, so that's the arrangement they have. Springer Napier, for me, that they shipped the book since 25th of February. We ordered some. We're not supposed to sell, but we are allowed a few. We're not supposed to sell in bulk. And because the bookstore was also having problems because they're printing on demand, they don't have these books available just so to sell. So it's on Amazon. If you request a copy, they will have to send the print. So I requested some to facilitate those who wanted to buy one. They wouldn't have to pay shipping. The book sells for $130 on Amazon and Palgrave website. And the hard copy book and the e-copy for $109, which you can get online. You prefer to buy and you have to wait for the shipping. Some people have asked. So we have requisition forms at the back there. You can put your name, your number, email, etc., and we will try to facilitate you in obtaining a copy if you so desire. So this is what it looks like. This is what the book actually looks like. So when you see it in Amazon or Palgrave, you are going to see it there. So we hope to get that shipment soon. Interestingly, they couldn't find the tracking number. Springer Napier, something went wrong. They sent me a tracking number which was wrong. But the books, I think they are in Trinidad. It's just that they cannot get it. Where is it? They couldn't find it. So with that, I want to thank all of you for being here. You've been very patient. I know this has been long for some of you who are not in the jurisprudence and regional integration. I'm retiring, but I hope it wasn't too boring. And I wanted to invite you to join with us in the reception as I call upon our dancers. Just the full will, just a brief vote of thanks, and then we will go to reception. So once again, we have Angelique and Blessed Savannah. They're going to do the Ganges and
So we've come to the conclusion of this evening's proceedings, and my very short and simple task is just to acknowledge and thank all of you for being here. I particularly want to mention those who have brought remarks this evening, in particular the Honorable Justice Adrian Saunders, President of the Caribbean Court. I think that his insights were very, very illuminating and really given us much food for thought. And so too, the remarks from our distinguished principal, Pro-Vice Chancellor, Professor Rosemary Bright Antoine, principal of St. Augustine campus. And of course, because of the fact that we have had a particularly close ability during the writing of the PhD thesis, which later became this book, to some extent, I think that really her remarks and her presence has really meant a lot to us. I also want to acknowledge the very distinguished former president, Sir Dennis Byron, whose, again, comments reflect not just a personal relationship, but also one that I think it's difficult to really put into words how much Sir Dennis has contributed. He was, whilst being president of CCJ, always willing to make himself available, and we met on various occasions to share some thoughts and to really be willing to be interviewed. I mean, it's a very busy short court schedule, and that really meant a lot to me, and I think to the Dr. Prasad as well. I want to, of course, also acknowledge others who are here, who have shared their time and energy. I know it's not easy on a Saturday evening to give up some of your weekend to spend with us, in particular, Senator the Honorable Wade Mark, Senator the Honorable Anthony Vera, Senior Counsel, both of whom we really appreciate your presence here with us today, and I know that both of you have a keen interest in this area. Others who are present with us, of course, who had to leave, Honorable Madam Justice Don Prowell, Chair of the Equal Opportunity Tribunal, who spent most of this evening with us, and Justice Deborah Thomas Felix, former President of the Industrial Court, as well as my colleague, Judge Roland Hussain, Judge of the Tax Appeal Court of Trinidad and Tobago. We've had others with us. In particular, I'd like to single out His Excellency Sejong Kwong, Ambassador of the Republic of Korea. We're truly honored by your presence, sir, and thank you very much for being here. We really, really appreciate it. Professor Derek Cheney, Vice Principal of UE, St. Augustine, as well as others, very distinguished senior counsel, some of whom we saw online, Mr. Martin Daly, and of course with us present today, Mr. Russell Martineau, and other members of the legal fraternity, as well as all of you who have in some way made this evening a very, very memorable one for us as we seek to contribute in some small measure to the dialogue on this important aspect of our jurisprudence within the region, and I dare say internationally, because sometimes we forget and we take for granted our distinguished jurists amongst us. And you've heard Justice Saunders refer to the fact that sometimes even our local jurists from the CCJ are not always recognized as they should be in other jurisdictions. And I think that speaks to the fact that there's a lot of work still to be done, whether or not you're adherent or you may not be a fan of the CCJ. The point is we should engage in dialogue. And I think it's important because when I first started the study, I was told by one of my earlier supervisors that we always know that Anthony loves the CCJ. And that was said not as a compliment, but to suggest that I might be in some way biased. And it was a very important comment because when you approach academic study, as I've learned over the years, you really have to bring a level of impartiality, not just because you may have a particular love for something or so, that you must allow it to color your ability to review it independently, impartially. And I'm grateful that Senator Vera is nodding that. I also want to acknowledge, of course, others who contributed to this evening. In fact, our dancers who did the two pieces there, Angelique and Valeska Val-Rapun, who really did a tremendous job to really make this evening very special. And of course, Ms. Gabrielle Simbu, I'm not sure if Gabrielle is still here, but I was very honored to share the platform with her. Dr. Rampersad has already emailed Professor Antoine to give me some lessons, but I think she may be resistant to that. I think she has too much else on her plate to take that out. But the point is that all of you in some way have really contributed to making this evening as a success. So we hope you'll spend a few more minutes with us. I'm sorry, of course, I also want to make reference to those from Dr. Rampersad's department. Darnell, Dale, who in particular have really helped us with the IT side, but also in all sorts of other ways as well. So thank you all very much, and please don't rush off, and please share with us a few moments as we invite you to some refreshments. So Dr. Rampersad, I'll give you the last, if you wish to say anything further.
If you want to come and now enjoy the refreshments, we also have a double stand here, so you can
Just the
take
projector.
and you can
Not the
eat, you
projector.
can take home. Yeah, it's extra. Okay, so enjoy. Those of you who want to go, don't forget to fill out the requisition form at the back.
Okay. Amazing.